In termination of employment, especially in the imposition of penalty, the principle of discretionary justice is very important. So we have to discuss this one. What is this principle? This principle has been laid down by the Supreme Court in order to temper management prerogative to discipline and terminate an employee. In the line of jurisprudence, the Supreme Court emphasized that in carrying out the penalty, the standard must be reasonable, and the penalty that is imposed must be commensurate to the offense. Otherwise, there will be injustice. Remember that social legislation, labor law being a social legislation, favors a particular group, the unprivileged working class. So this principle of discretionary justice is in line with that principle of social legislation. According to the Supreme Court, in the case of Almira versus B.F. Goodrich, where a penalty less severe would suffice, whatever missteps may be committed by labor ought not to be visited with the consequence so severe. It is not only because of law's concern for the working man, but you have to consider that if the employee is terminated, you also have a family waiting and in need of food, clothing, shelter, and medicine. So if you terminate an employee, you will not only make one person suffer, but the entire family. So in line with this ruling, management is encouraged to exercise its prerogative that in the imposition of penalty, the less harsh should be imposed. Termination would only be the penalty of last resort unless it is validly justified. So if the penalty that is imposed is too harsh, then the laborer can go to court and have the termination declared illegal. An employee who refused to undergo drug test because the policy is so vague, it is not properly defined what is unjust refusal. According to the Supreme Court, in the case of Mirant Philippines Corporation and Bautista versus Joselito Caro, April 23, 2014, the Supreme Court ruled that the employee should not be terminated. The Supreme Court only imposed suspension without pay for 4 months. The rule of commensurateness of the penalty to the offense charge is also a very important criterion. If the offense is light or less serious, the maximum penalty should not be imposed. So it could either be suspension for a number of days, or for light offenses, the first offense should merit only reprimand, is either oral or in writing. So we have to observe gradation of penalty, and it must commensurate to the offense charge, which means that a light offense must be meted with light penalty. In fact, the Supreme Court, in applying the principle of discretionary justice, used or imported the principle of aggravating and mitigating circumstances. In the case of Narciso Matis versus Meralco, in this case, length of service would show that the employee has been loyal to the employer. So which means that the longer you stayed in the company and you betrayed the trust reposed on you by the employer, that would be considered as aggravating circumstance. You are expected that the longer you stayed in the company, the more you should be loyal. And the company has already invested trust and confidence over the employee. On the other hand, the length of service was considered mitigating circumstance. In the case of Universal Robina Sugar Milling Corporation versus Ablay et al. In this case, the employees were terminated and their jobs, and they were performing jobs as equipment operators, technicians, and electricians. And the incident involved damage to a forklift, and it was only their first offense. So looking at the length of service of the employee and the nature of the offense, then it was committed for the first time, and the Supreme Court ruled that termination should not be proper. That's the principle of discretionary justice. To sum it up, when you talk of application of this principle, the policy or the source of discipline, which is a company policy or code of discipline, it must be reasonable. And the penalty must be commensurate to the offense. Third, the termination of employee must be the last resort. And if you are going to analyze the just or authorized causes, if you read the letter of the law, the just and authorized causes give the employer the discretion, because it provides that the employer may terminate, which means that the employer can exercise his or her discretion on whether or not to terminate the employee or use his discretion to impose lesser offense. So in applying the principle of discretionary justice, other than the policy that is reasonable, we should also include the appreciation of mitigating and aggravating circumstances. When you talk of aggravating or mitigating circumstances, the length of service should be considered, As to whether the offense was committed for the first time, that's another factor to consider. So if the employee has been working for 20 long years, has been loyal to the company, but just because of one misstep or offense, it is not proper to terminate the employee. So the length of service should be appreciated as mitigating circumstance because the offense does not involve betrayal of trust. However, if it is betrayal of trust, then the longer the time that the employee spent with the employer shall be considered as aggravating circumstance. So those are the factors that you have to remember in applying the principle of discretionary justice. Again, the policy must be reasonable, the penalty must be commensurate to the offense, and termination must be the last resort, and the employer must appreciate mitigating and aggravating circumstances. Let's go to the discerning compassion doctrine. This is a situation where an employee is terminated. However, the Supreme Court requires the employer to give financial assistance. This is a form of compassion to the worker who is terminated. However, there is a qualification that in order for financial assistance to be given to the employee, the act committed by the employee is not serious misconduct and it did not reflect the moral character of the employee. In the case of Manila Water Company versus Del Rosario, January 29, 2014, the Supreme Court allowed the giving of financial assistance as a measure of social justice. However, according to Supreme Court, the basis for termination of the employee must not be serious misconduct, willful disobedience, gross and habitual neglect of duty, fraud or willful breach of trust, commission of a crime against the employer or his family, or those reflecting the moral character. So if the employee committed gross negligence but not habitual, then the employee can be terminated, and it is but proper that the employer should give financial assistance of 5,000. Because the law requires that the act must be considered gross and habitual in character. The act of neglect must be gross and habitual in character. So if it is gross, but in terms of amount, as the case of LBC, where the amount of the loss of motorcycle is 40,000 plus, it was considered a ground to terminate. Since it was not habitual, it's only gross neglect, then you have to give 5,000. If it is gross and habitual neglect, then the employer should not give 5,000. If the employee is grossly inefficient, involved in the use of illegal drugs, then you cannot be compelled to give financial assistance of 5,000. So just go ahead and terminate the employee. However, there is one case of Digital Telecommunication Philippines Incorporated versus Ayapana, January 10, 2018, where the Supreme Court granted a higher amount. The court granted separation pay of 1 month to the employee who was terminated based on willful breach of trust. However, this is a unique situation where the employee, according to Supreme Court, was just compelled, was just acting due to jealousy in acquiring and retaining subscribers and not to misappropriate company funds. Secondly, there was no moral depravity in the part of the employee. In fact, he has been a recipient of certificate of commendation from the company or from the employer in years 2001 and 2002, being an outstanding account manager. And he was even granted promotional increases. So there were other considerations in this case which prompted the Supreme Court to give the amount of 1 month salary to the employee as a form of financial assistance. So it may not be only 5,000. So if there is a similar case or a theoretical question similar in nature to the one that I mentioned, then the 5,000 rule will not apply, but a 1 month salary. So in other words, the principle of discretionary justice, discerning compassion doctrine, as a form of social equity, requires the employer to give financial assistance to an employee who is terminated in order for the employee to find another employment, to secure all other clearances as it may be required by the next employer, and also for the time that he has no employment, at least he has money to feed his family and provide their needs. Always remember, the discerning compassion doctrine applies in valid dismissal based on just cause only, not in authorized causes. Take note of the limitation that the ground or the just cause must be other than serious misconduct, willful disobedience, gross and habitual neglect of duty, fraud or willful breach of trust, commission of a crime against the employer or his family, or those reflecting on his moral character.